Today we're going to talk about copyright. In particular, we're going to talk about how do you spot copyrighted material, how you know whether you own or can use the copyright material, what do you do with all those images that you find on the web, and what's going on with AI now that we have ChatGPT and OpenAI and all these other tools coming into effect. So let's dive right in. This is Sharon from HTBiz Law, and we are going to bring you everything that you need to know about copyright. So the first question is, what is copyright and how do you spot it? Very simply, copyright covers anything that is a work of authorship, that is a report, a drawing, artwork, music, a computer code, an app, macros, spreadsheets, a Word document. Anything that you have authored or created is covered by copyright law in the United States and the majority of countries around the world. You often can tell if someone has copyrighted it if you've seen a C in a circle, the year, and their name. However, just because you don't see a copyright notice doesn't mean that someone doesn't actually own it. That is because under copyright law, the second the author creates that work of authorship or copyrightable material, all of their rights spring into existence immediately upon creation without them having to do anything else. And what are those exclusive rights that the author holds? It's the right to use it, to copy it, to modify it, to perform it, to create a derivative work, or to publicly display it. Now, believe it or not, to display a work can include even putting it on your computer monitor. But those are the rights of the author, and the author keeps or retains all of those rights except for those rights they expressly give away. And expressly give away means either through an assignment or in a license that's in writing, so that there's no question whether or not any or all of those rights have transferred. So the copyright owner could give someone the right to make a copy, but do nothing else. They could give someone the right to perform the work. For example, if somebody wrote a play, they may grant someone a license to perform the work, and they might give them a license to perform the work only in the United States or only in France. Copyright works by keeping all the rights for the author except that which they give away. So they can use the things many, many times. So you need to be careful that if you find work, and we're going to talk about that a little bit more, that you know whether or not you have the right to use it. And the short test is, has someone given you in writing permission to use it? If they haven't given you permission to use it, 95% of the time, you can't. Now, there are a few exceptions, which we'll talk about in a minute, but you have to remember, if someone didn't give you the rights, you don't have the rights. So how do you know? Well, first of all, we need to do two things. We want to make sure that anything that you created or that you think you have created and that you think is yours is actually yours. And the other thing we're going to talk about is, if you found something else, can you actually use it? So how do you know if something is really yours? Well, you might think, if I've paid someone to do it or I've hired someone to do it, I own it, even if I didn't personally create it. That isn't always the case. If you have an employee who creates a report for you or some other copyrightable material, and the employee, and now I'm talking about in the United States, a W-2 legal employee, if an employee has created that work for you in the scope of their employment as part of their regular duties, then you as the employer will in fact automatically own the work by, quote, operation of law. Because under copyright law in this country, if your employee has created it as part of their regular job, and you hear me emphasizing that, and I'm doing that for a reason, and I'll explain that in a moment. If they've created something for you as part of their regular duties, then it will belong to you. If, however, for example, you've hired someone to be a computer programmer for you, and what they did was not create a computer program, but they created some artwork, not as part of their job, just because they created it, and you want to use it, actually the employee probably owns it because they were hired to be a programmer, not an artist. Being an artist and creating a painting that you want to use or taking a photograph that you want to use is outside the scope of their employment. So if you hire someone to be a computer programmer and they write software for you, you as the person who hired them will own it and be the copyright owner. But if you hired them to be a programmer and they created artwork, they are probably going to own that artwork and you can't use it without their separate permission. Now, a second situation is, have you hired a contractor? Not an employee, but somebody who works for you on maybe a project-by-project basis or an occasional basis. They're a consultant, they're an independent contractor. If they are not a legal employee, no matter how much you pay them, if they have not assigned the work to you in writing, in a contract, or if they have not granted you license, i.e. permission to use the work in writing, you can't. Because under copyright law, an independent contractor owns everything they've done. They are not considered an employee where the rights move automatically. If you've personally created the work 100% yourself, you own it, no question, if you're the boss. If you've created the work but you work for somebody else, your boss owns it, if it was part of your job. So I'm now talking to all of you bosses, entrepreneurs, small businesses. You wonder now if you own, in fact, everything you do. What you want to do is sit down, take a look at all of your key information, your key software, reports, those things that bring special value to your business, and think about who actually created them, and were they created as part of their job as an employee, or were they created by a contractor, or were they created by you? If they're created by an employee in the scope of their employment, you own it, you're good. If you created it, you're good. If a contractor created it, you need to look at the contract and make sure the contract that you signed with that independent contractor either assigns or licenses the rights to you. Otherwise, you won't have the right to use that under copyright law. And if you do, you can get in trouble. And I've seen this happen where it often happens in the situation where in the beginning of a business, friends get together, they help each other, it's done on a handshake, you all were working in a garage. There were no contracts, there were no documents, it was all done on a handshake because you're friends. And then the app or the software product or the book or the course takes off. It becomes huge and somebody wants to buy your business. At that point, the person who's coming to buy your business is going to take a look and see, does the business actually own, or do you actually own everything in this thing that they want to buy, or maybe they even want to buy your whole company. If your friends on a handshake never signed anything, they own everything they did and they're going to get paid off. I've seen this happen to the tune of millions of dollars. This really happens. So you really want to make sure you do an ownership check now, that anything that you have of value, reports, drawings, software, you know who created it and you make sure that you own it. What about something you find on the web? That's the third thing we're going to talk about today. You see images on a web, or you see text on a web or a story on the web that you would like to use. You have to remember there is a difference between something that is publicly findable, for example, using Google Images, and I have the right to use it. Because you have to remember, we talked about this at the very beginning of today's episode, copyrights belong to the author the minute they are created, even if you don't have a notice saying it is your copyright. It's still yours. A notice is really important because it lets the world know. But even if you didn't have the notice, you would still be the copyright owner if you created the work. And that is the same thing for everything you find on the internet through Google search or any other search engine. Unless someone declares in using the words that the item is in the public domain, that has legal meaning, public domain, which means they have given the world the right to use it, typically for free, kind of like open source software. You often can use it without paying any license fee. You just have to include the open source notice. But unless something is public domain or a form of public domain, you don't have the right to use something that you have found. And there are businesses out there that search for copyright owners to see if someone's image is showing up somewhere that they didn't grant a license for. So if you're using Google Images or finding things on a website from somebody else, you have to be very, very careful about whether or not you are allowed to use it legally. Because if it's a great photo, I guarantee you that author, the photographer who took that picture, is going to want to protect its use. You could write to them and see if they'll grant you a license, but I wouldn't just take it and put it up on your website. That is copyright infringement, and that is subject to paying dollar damages. And if that person actually filed for copyright registration, it's an extra optional step. They could get somewhere between $500 and $30,000 every time someone makes a copy of their work under the copyright registration statute. But even if they don't, if they can prove damages, I normally license my pictures for $5,000 at a time, they could sue you for that amount of money for each copy that you make, each time that you make it. So you take that image, you put it in a newsletter, you send that newsletter out to 100 people. Each one of those times you sent it out to a newsletter is considered making a copy. So just imagine 100 newsletters times $5,000 a copy is $500,000, right? That's a lot of money that you could be responsible for. So make sure that you are not using the work that belongs to somebody else. You have to remember, just because you can find it on the web doesn't mean you can use it. And if you look at websites such as CNN or other major companies, there's going to be a copyright notice on the bottom of every page of their website, which I think everyone should do, which is see in a circle the year the work was created and the name of your business. They're also going to have something called a terms of service or legal notices, and that you will find if you read them, most people don't, but you need to, it will typically say all of the work on our website is ours, and it will say what you can and, more importantly, cannot do. I'm sure they will give you the right to read the material for your own personal use, but in most cases, they're going to have something in their terms of use that say, you may not use this for any other purpose. And they will enforce these rights. So now we come to AI. Artificial intelligence is taking over. There's so many different tools out there, ChatGPT, other things from OpenAI, other platforms. And now you have to wonder, if I've used ChatGPT or any other of the AI, what happens to copyright? Do I own it? Can I get a copyright in something that has been created by ChatGPT? I wrote the prompts. I told them what to write for me. Shouldn't I own it? Unfortunately, and there was actually just a case very recently on August 18th that held, if something is created by artificial intelligence, whether it's artwork or a report or a story, you cannot get a copyright in it. Just because you wrote the prompts doesn't mean you wrote the output. The Copyright Office agreed. They even have some guidelines out. They've actually been out for a few weeks, actually a few months at this point, about AI. You must have the human element of creation. So if you wrote something using AI and you didn't change any words, you just copied it and pasted it into a book and you're trying to claim copyright over that piece, you can't. It is not considered yours as in copyrightable, because technically somebody else could ask the same questions and ChatGPT or any other AI could create the same answers. It has to be original work of authorship, and it must have, and this is what the court held and the Copyright Office agreed, human creation. Now, can you take something from artificial intelligence to give you the base? You might say, ChatGPT, can you write an outline for me of a 5-chapter book on this topic? I want to cover these 10 points in the outline. ChatGPT gives you the outline. You then take the outline and use the outline to write the content yourself. That would be the element of human creation. You used the AI as a tool, not as the author. So if you want to use artificial intelligence to help you write a post, write an article, write a book, remember that whatever that artificial intelligence engine created for you that you don't change, you cannot get copyright protection in. So somebody else could use those exact same words in the exact same way, in the exact same order. So make sure that if you are using any artificial intelligence engines to help you, that you edit the work, that you revise the work, that you add that element of human creation, and then you're going to be able to get copyright in it. I realize we've covered a lot. You can reach us across any of our platforms. We are on YouTube, on LinkedIn, on TikTok, on Instagram, on Facebook. You can find us on the web at www.htbizlaw.com. You can check out the comments. You can check out our captions, our show notes. Everything is going to be in there for how to reach us. We have solutions for a lot of the questions. We even have a guide called Securing Your Brilliance, a hands-on workbook to help you identify and protect your copyrights. So once again, this is Sharon from HTBiz Law. Stay safe out there.